It's not a secret that sometimes when you enter a contract with a company, with a corporation, small corporation, bigger one, you might be defrauded by the owners, the shareholders, or administrators of this corporation when it was specifically created to solicit some money from you and then to present it as an insolvent debtor, saying that, okay, well, maybe you have a right to require some money, to claim some money from the corporation, but, well, we don't have any money, so sorry, maybe you have all the rights, but you will not receive your money back. So in such a situation, can you go against the owners, the shareholders, the administrators, the directors of the company, as opposed to the company itself? This is our question today. So, whom shall you sue if you want to sue? The company, but the company doesn't have any money, the owners, the shareholders, the directors of the company, all of them. How does it work? Well, originally, so the presumption is that if there is a corporation, then the corporation is separate from the persons who formed this corporation. There might be some other companies who formed this company. There might be some other people who made this company. But still, it's distinct, it's different. So if the corporation is deeply in debt, that doesn't mean that the owners of the corporation are deeply in debt. And in the normal course of doing business, that's the very idea of corporation, to shield its owners from possible debts, from bankruptcy, so that the shareholders only risk the value that they actually put into the corporation, but not their own property, their personal assets. So that's the starting point. And if the owners, the administrators of the corporation can prove that in doing business with you, they did not have this like fraudulent intent, this fraudulent act, that it was, well, just a regular situation on the market just went down, for example, or there was COVID, as you remember, for example, and the supply chains were all broken all over the world and so forth and so forth, then so there is no fraud or something similar to that. Then, unfortunately or fortunately, depending on which side you're on, even if the company is bankrupt, you cannot go through the corporate veil, so-called, and to go after the shareholders. But according to the Article 316 and further of the Civil Code of Quebec, if there is fraud, but you'll have to prove that. If there is fraud, fraudulent intent, fraudulent actions, so if it's clear, or at least it could be presumed based on the facts, that the corporation was actually made, organized specifically to perform this kind of transaction with you, financial transaction, monetary property kind of transaction, real estate transaction, when it was from the beginning planned, sort of, that you'll put your money into the corporation, give them your money to the corporation, but you will never receive what you paid for, because the corporation would go bankrupt or otherwise reorganized or whatsoever. Then, in such a situation, you can go against the shareholders if they control the corporation specifically, or and the administrators, the directors of the corporation. Very often, actually, in such a small, usually corporation, directors and shareholders are the same people, and that's one of the factors to consider when the court analyzes if there was a fraudulent intent or not. But of course, the very fact that the small corporation had the shareholders as their actual administrators. That does not presume that they were acting fraudulently. It's just one of the factors to consider. So basically, there are two conditions which, if you want to go after the corporation and the shareholders and the administrators, you have to satisfy. You'll have to prove that in the business transaction, whatever the nature of it was, there were indications of a fraudulent nature, of this preconceived intent to defraud you, and that the company itself existed in your particular case or in many similar cases only to protect the actual perpetrators of this fraud from you getting against them, so that you could only get against their company. There are many factual factors to consider. They are very specific to any particular situation. So if you find yourself in such a situation, it's a good idea to consult a lawyer and maybe even hire a private investigator sometimes. But the very idea is like that. Normally, you cannot sue the shareholders and directors of the company. You can only sue the company. But if you can prove that there was a fraud, then there might be a possibility to sue the shareholders and the administrators, the directors of the company. Here it is. Thank you, and have a nice day.